Hello, everyone. Thank you for joining us today for Venable's monthly series of webinars on legal topics of interest to the nonprofit community. I'm Janice Ryan, co-chair of Venable's nonprofit organizations practice, along with my partner and fellow co-chair, George Constantine. Today, you will hear from our talented colleagues, Meredith McCoy and Justin Rusk, on our topic for this month, FARA in Focus, what shifting scrutiny of foreign relationships means for tax-exempt organizations. Meredith and Justin both have substantial experience advising nonprofit organizations on compliance with the Federal Foreign Agents Registration Act, and you will come away from today's session better prepared to understand how FARA applies to nonprofits and how states are increasingly seeking to regulate in this space. Before I turn things over to Meredith and Justin, I encourage you to save the date for next month's webinar on September 17th at noon Eastern, entitled AI and Copyright, What Nonprofits Need to Know. So please be on the lookout for that invitation, which should be arriving in your inboxes very soon. Meredith, Justin, please take it away.
Thank you, Janice, and thank you everyone for joining us today. I'm Meredith McCoy, a partner in Venable's political and nonprofit groups, and I'm joined here by my colleague Justin Rusk. And both of us have spent a lot of time over the past several years in particular advising nonprofits on how FARA applies. And so we're excited to join you all today and share some of what we've learned and what we're seeing in the future. Our agenda today is going to start with a little bit of background, including what the purposes of FARA are and how that and the consequences that it has for organizations today. We'll move into a summary of the Federal Foreign Agents Registration Act, which is the federal law governing disclosure of relationships with foreign partners, and then talk briefly about the recent enforcement trends we're seeing under the current administration and the recent development of state regulation in this space. We'll finally finish out with some practical tips, especially geared towards nonprofits and the particular issues you all face. If anyone has questions at any time, please feel free to drop them into the chat and we'll try to get to them as we go. So for context, FARA is a federal statute that was originally enacted in the pre-World War II era in an effort to bring transparency to Nazi propaganda in particular in the lead up to the war. It has lain dormant for a lot of its existence. It was not heavily enforced for a very long time, and the last comprehensive amendments to FARA were in 1966, which came in response to increased efforts by foreign governments to jockeying for a share of the sugar trade after relations with Cuba deteriorated in the middle of the century. But since then, it's not been substantially overhauled and largely was enforced very rarely until we get to about 2016, when after the 2016 elections and the reports of foreign interference in those elections, the statute gained renewed prominence. And since 2016, the Department of Justice, which is charged with criminal and civil enforcement of the law, has brought more enforcement actions than in the entire preceding half century. So one thing to know about FARA is that it does not prohibit any activities on behalf of a foreign principal. The primary purpose is to promote transparency of relationships with foreign entities. And so this is important because there is a huge stigma around FARA registration, but it's important to know that it doesn't prohibit organizations from engaging with foreign partners or representing foreign partners on US soil. It's a transparency statute, so it wants the American public to be able to know when an organization in the US is acting on behalf of a foreign partner. Registrants who are required to register under FARA have to comply with a series of disclosure obligations. The first is an initial registration, and this is filed by the organization itself and is newsworthy because it includes some information that is potentially sensitive to an organization. Among the documents that have to be filed are copies of the organization's governing documents, their articles and bylaws, as well as a copy of any compensation agreement or any contractual arrangement with a foreign principal, which we'll define for you in a second. So a lot of organizations who may be accustomed to, say, lobbying registration or even campaign finance registration obligations will find it notable that here you're actually filing copies of your contractual agreements or describing the arrangements if the arrangement isn't on paper, and filing your governing documents with the government. In addition to the organizational registration, short form registrations are required from each individual who performs non-clerical services for the foreign principal. And these registrations are noteworthy because they include the individual's birth date, residential address, and their personal contribution history. So again, fairly personal information. Once registered, an organization files supplemental filings every 6 months. These include an update on the organization's activities on behalf of their foreign partner, and includes updates on the amount of money an agent has received from a foreign principal or has dispersed on behalf of a foreign principal. Now, in addition to the registration and ongoing reporting obligations, there are specific requirements around informational materials, which are materials that are published to expected to be published to at least 2 individuals outside the organization. And so these informational materials have to be submitted within 48 hours of publication on behalf of a foreign principal and are available for the public to view. In addition, I think we can move to the next slide. In addition to these 48-hour reports, which is a fairly quick turnaround, the informational materials also have to include a specific disclaimer disclosing the fact that the person is an agent registered under FARA and identifying the foreign principal on whose behalf they're registered. Agents also have to identify themselves as being FARA registrants when they interact with U.S. government officials, including when providing congressional testimony. So this all points to the fact that FARA registration, while it doesn't prohibit any activity on behalf of a foreign principal, it can impose relatively burdensome registration and reporting requirements, and that alone can deter certain organizations from wanting to be registered. I think there are also some nuances which Justin can speak to about just the quirks of the filing system, which is not one of the most modern. Justin, do you want to jump in there?
Yeah, absolutely. If it wasn't clear already from Meredith's broad overview of FARA and the purposes and the reporting requirements, it is very burdensome. In working with clients who do have to register, who do have to file reports, I will say that for those who have experience with state or federal lobbying, FARA is by far the most burdensome reporting regime that I'm aware of in terms of lobbying. The registration itself, which must be filed within 10 days or before engaging in any registrable activity, trying to meet that 10-day requirement is tough, just given all the documents Meredith mentioned, articles of incorporation. You need to get wet signatures. You need to disclose political contributions by those employees who are going to engage in FARA registrable activity. So they need to go back and see what political contributions they've made at the federal, state, and local level. You need wet signatures to go to the FARA unit. So there are a lot of just administrative requirements involved in getting to the point where you can file reports. And then the reports themselves are incredibly detailed, more so than, again, any other state lobbying regime. If you are communicating with policymakers or the media, you need to disclose what day you spoke to them. You need to disclose the name of the individual you spoke with and what you talked to them about. So for some registrants that are engaged in significant lobbying or public relations activities, they may have hundreds and hundreds of contacts that need to be disclosed every 6 months. And so organizations need to start thinking about a system to track all of that because can get very unwieldy quickly.
Thanks, Justin. And at Venable, we do help organizations navigate these compliance programs that are necessary to comply with FARA. So it can be done, and there are certainly plenty of organizations that are registered under FARA. But you do want to keep in mind the other consequences that flow from FARA registration. As I briefly mentioned before, there are reputational considerations at play here. There is a certain stigma, especially in today's political environment, associated with acting on behalf of a foreign country. And so there may be political or public considerations you want to take into account before you hit the requirement to register, before you engage in these relationships with foreign partners. You want to understand how that will play out in the public sphere. In addition, just briefly keep in mind that registration under FARA can affect your eligibility for certain government contracts or positions. Notably, under the Biden administration, the Biden Ethics Pledge included restrictions on those who had been registered under FARA and their ability to hold certain positions within the administration within 2 years of their registration. Also, many organizations applied for PPP loans during the COVID epidemic, and receipt of a PPP loan was restricted for those who were registered under FARA. So that is not a uniform restriction across the board for government assistance, but know that it was included in a very widely used government assistance program during the pandemic. So from there, I will hand it off to, oh no, I have one more slide, my apologies. Do I? No, I'll hand it off to Justin to talk you through the basic elements of FARA.
Great. Thanks, Meredith. We'll spend the next couple of minutes here doing a FARA 101, talking about the various triggers and things to consider before you get to the stage of registration, or the activities that may cause you to need to register. So under FARA, who must register and report? The short answer is an agent of a foreign principal needs to register and file reports with the Department of Justice if they engage in certain covered activities within the United States, unless an exemption applies. And a very important distinction of FARA compared to a lot of other lobbying or other disclosure regimes is there is no de minimis threshold. Even a single contact or a single registrable activity is enough to meet the requirements under FARA. The analysis for those who may have an obligation to register is really 4 parts, 4 questions. First, is there a foreign principal involved? Second, have you established an agency relationship with that foreign principal? And third, if you have established an agency relationship with that foreign principal, are you engaging in certain enumerated activities on behalf of that foreign principal? If the answer to those first 3 questions are yes, then you have an obligation, you're an agent of a foreign principal, and you have an obligation to register under FARA with the Department of Justice, unless, the 4th question, an exemption applies. So we'll go through all 4 of these questions and understand these steps a little bit further. So first, we'll take a look at what a foreign principal is. There are 3 broad categories of foreign principals. First are foreign governments, and that's traditionally been the focus of FARA enforcement, and the core of why it was passed was to shine a light on foreign government influence within the United States. So this includes governments and their agencies, political parties, including minor political parties or parties that have no control within the government itself. It would also include factions, informal political type organizations, insurgent groups, and also sovereign wealth funds, since they are in fact an arm of the federal government, their government, their foreign government, and other just agencies of foreign governments would all fall within this first category of foreign principals. The second category are just individuals outside of the United States. So it doesn't have to be a foreign government. It doesn't have to be a foreign entity. It could just be a foreign person that you're an agent of. So this would apply to non-US citizens and those not domiciled within the United States. And then the third category of foreign principals would just be foreign organizations. So this could be a foreign corporation, some other type of foreign business entity. Relevant here, it could be a foreign nonprofit, perhaps, that you're partnering with or contracting with. It could be other foreign associations, whether they're formally registered or not within their country. What we're really looking for are just any type of entity that's organized abroad, has its activities primarily abroad. That would all be under the umbrella of a foreign principal, which is the first question. We have to have some type of foreign principal for FARA to be possibly relevant here.
And before you move on, Justin, I just want to highlight for this particular audience the types of foreign principles that really have attracted attention in recent years are the sovereign wealth funds and associations who are representing that have foreign companies as members. And those are two of the big ones. It's not to say that other types of foreign principals won't attract scrutiny, but if your organization is receiving funding from a sovereign wealth fund or a foreign government, or has members that are foreign companies, particularly if those foreign companies have any governmental ownership, you should really be thinking about how FARA applies to you.
Yeah, absolutely. I'll also add too that foreign governments are also very aware of FARA and the stigma that it applies to those who need to register, and they are getting pretty creative about the entities that they're working with to try to influence US policymakers or government. So it's not always clear that there's a foreign government involved too, and that's been a focus of the FARA unit of late. So now we'll talk about agency. So again, you have to be in an agency relationship with a foreign principal before registration is even potentially applicable. So agency is not very bright line in terms of you don't always know when you're in an agency relationship. It's not as clear cut as you just have a contract with a foreign principal. The statutory definition is a person who acts as an agent, representative, employee, or servant, or any other person who acts in any other capacity at the order or request or under the direction or control of either a foreign principal, so one of those three categories of foreign principals we talked about, or an intermediary, a US intermediary potentially. So this is a person whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in major part by a foreign principal. So for example, you could consider a US subsidiary, a US affiliate of some foreign corporation. If your relationship is with them, it may flow up through to the foreign parent under FARA, even if, as a matter of contract law, you're not in an agency relationship with that FARA parent. So it can be quite broad as far as how you can establish an agency relationship. Continuing on this theme of agency further, the Department of Justice has issued some guidance on the scope of agency and the factors that they will consider, and the courts have provided a little bit of a bright line test, although it's not very bright at all, in my opinion. But the question that they provide is whether it is fair to draw the conclusion that an individual is not acting independently, is not simply stating his or her own views, but is acting as an agent or alter ego of the foreign principal. So this kind of concept of whose interests you're promoting, particularly for nonprofits, is going to be a critical one in terms of the agency analysis and also some of the exemptions that we'll talk about shortly. A very important note when it comes to FARA is that funding from a foreign principal is a key consideration in the analysis, but it is neither necessary nor sufficient to establish agency, meaning you can establish agency with a foreign principal even if they are not paying you. And you can also not be an agent of a foreign principal even if you are receiving some type of funding. Some of the factors that would be considered to this relevant to nonprofits. So is a foreign principal funding a U.S. organization's activity? If so, what proportion of program is funded by the foreign principal? Is it a small part? Is it a large part of the organization's overall funding? Is a foreign principal earmarking money to be used for FARA registrable activity? Is the grant specifically to influence U.S. lawmakers, for example? Are there any other contingencies on the funding? Does it require the U.S. organization to engage in specific conduct? Does it require the organization to report back to the foreign funder, meet certain benchmarks for the foreign funder? Importantly, does what the U.S. organization is doing fit within its own mission? If so, that tends to cut against an agency relationship because the U.S. organization is acting independently. It's doing what furthers its own mission, not just that of the foreign principal. And so we would also look at whether that activity is connected with the U.S. organization's viewpoints, its own goals, its own directives from its own U.S.-based governance, versus whether the U.S. organization is now just simply acting as a mouthpiece for the foreign principal. We'd also want to know if there are any individuals within the U.S. organization that are being directed by or responsible to the foreign principal. Another consideration is timing. Did the U.S. organization start engaging in a new type of activity simply because they got funding from a foreign principal? If so, that could be an indicator that now you're acting as an alter ego for that foreign principal. You're doing something just because they asked you to and that they funded. So that's a key consideration as well. And then, another one is, do foreign principals or foreign individuals participate in the decision-making by the U.S. organization? For example, are there foreign principals on the board of directors of the U.S. nonprofit? Are they members? What type of member are they? How much control do they have in setting policies or direction for the U.S. organization? So putting this all together, it is not always clear when and if an agency relationship exists. There are a lot of different ways outside of a very straightforward contract that you can establish agency with a foreign principal.
Justin, we have a question from the audience. Does this apply to a college or university that receives funds from a foreign government to pay tuition for students from that country? And so, can you speak to that, or I'm happy to?
I guess the short answer is colleges and other academic institutions have been subject to FARA scrutiny for funding that they are receiving from foreign governments. But just because they are receiving some type of foreign funding does not automatically establish an agency relationship. Again, there are a number of factors that would be considered there. And even if it does, in that nuanced instance or that specific instance, create an agency relationship, in the context of tuition for an academic program, it may nonetheless be exempt, as we'll talk about. So again, back to continuing on agencies for the nonprofit as an agent, what this slide is trying to visualize is just there are a lot of different ways that a nonprofit could become an agent of a foreign principal. First, you could have a non-U.S. donor. You may have an agency relationship with them. You may have a grant or a contract from a foreign government or some other type of foreign entity. That itself could establish agency. Maybe you're in a partnership with an international organization, whether that partnership is formal or informal, that itself could establish an agency relationship with a foreign principal. Or maybe you're a U.S. nonprofit or U.S. trade association that has international members. That relationship, that connection with your members could be viewed as an agency relationship. Or the inverse, maybe the U.S. nonprofit is a member or representative of an international organization, and that international organization has expectations or requirements for those who are members of the organization. Again, that could be a possible agency relationship. And then finally, for nonprofits that may do impact litigation or represent foreign clients in certain matters, that relationship could be an agency relationship under FARA.
So we have another question that came in about agency relationships and whether this would apply in a situation, or would agency exist in a situation where a college or hospital, say, receives foreign funding to conduct research that benefits the funder? And I think this is a really good question, and is actually a good contrast from the previous question about tuition, because I think when tuition, it's the tuition payment itself probably alone would not create an agency relationship. But when a foreign entity is providing funding for research that really serves the foreign donor's interests, I think that's a situation where we do want to dig down on the nuances of the relationship. And so, for example, there's a pretty notorious opinion from the Department of Justice where a very prominent US nonprofit received a grant from a foreign government to engage in activities that the nonprofit felt was very consistent with its mission. It was in the environmental space, and it felt like the work that had been enabled by the grant was very consistent with its mission and wasn't really directed or controlled by the foreign government. But DOJ, in issuing an advisory opinion, came down on the side of the fact that there was an agency relationship that did require the US nonprofit to register. And it took into account the nuances of that grant agreement and the fact that the nonprofit, even though it was acting in its own interest, was also delivering on the interests of the foreign government and had certain obligations to report back. And while this opinion got a lot of blowback from the nonprofit community, and I think DOJ heard that blowback, this one opinion was very alarming and serves as sort of a warning to organizations that if you are receiving foreign funding, we want to be really attentive to the details of that funding relationship, particularly when the work that will result is both in the interest of the organization and the donor.
Okay, we'll kind of keep this moving and go on to covered activities, which is the third question under the FARA analysis. So let's assume now we are an agent of a foreign principal. We want to know, are we engaged in covered activities? And under FARA, the statute is very broad, and lots of different types of things are technically FARA registrable activities. But the focus of FARA has historically been political activity, lobbying or other activities intended to influence policy. But it also covers publicity and public relations activities, soliciting, collecting, or dispersing funds, so fundraising, very relevant to nonprofit organizations, and any type of representation before the US government, even if it's not intended necessarily to influence policy, but rather you're representing somebody's interest before the government. So we'll break these covered activities down a little bit further. First, political activities. Again, this is often thought of as the core focus of FARA, intended to regulate political influence from foreign governments. The FARA unit views this definition very broadly. It's any activities intended to in any way influence any agency or official of the US government, or notably, any section of the public within the United States with respect to domestic or foreign policy of the United States, or very broadly, the political or public interest policies or relations of a foreign government or political party. So examples, the classic one is lobbying. So if you're lobbying on behalf of a foreign principal, that's political activity. But it's broader than just the traditional meeting directly with lawmakers type of lobbying. And it's very different from any type of lobbying that you may be familiar with under the tax code. The FARA unit views behind-the-scenes strategy consulting as political activity. So even if you're not doing the direct lobbying, you're providing advice as to who the FARA principal should talk to. That counts. It would also cover issue advocacy or grassroots type lobbying. Even public education programs can be covered if the intent is to influence a section of the U.S. public about some type of a policy. It is even extended to promoting tourism or business opportunities in a foreign country. That's an area that really is not intuitive, but at least since the 80s or before, the FARA unit has taken the position that promoting tourism or business opportunities is political activities because of the benefits that flow to the foreign country and the foreign government. The department earlier this year in proposed rulemaking, which we'll talk about later, has walked back a little bit the tourism part, but there is still certainly a line of advisory opinions talking about investments in promoting business opportunities to foreign governments, to foreign countries as political. Next is publicity and public relations activities. So this is any person who informs, advises, represents a foreign principal in a public relations matter involving that principal's public or political interests, policies, or relations. It also includes acting as a publicity agent, which is pretty broadly defined as any person who engages directly or indirectly in the publication or dissemination of oral, visual, graphic, written, or pictorial information for a foreign principal. So if you are disseminating research or other types of information like that, that could be covered as a publicity agent. And then perhaps even more broad is this concept of an information service employee. If on behalf of a foreign principal, you are furnishing, disseminating, publishing information about the political, industrial, employment, economic, social, cultural, or other benefit, advantages, facts, or conditions of a foreign country or principal, that's covered activity. So you'll see FARA casts a very broad net in terms of what type of activity is registrable. So under these types of activities, I mean, it could include research, it can include public education. Advisory opinions have also talked about cultural exchanges, where you're working with a foreign country to connect individuals from that country in the United States to foster cultural understanding. That can be covered activity. Even language and history teaches can be covered under these definitions. And something like promoting a conference that you're partnering with an international organization on, if you're publicizing that conference within the United States on social media, however, that can get you wrapped up in these types of covered activity roles. So I see we have a question here about making an introduction on behalf of a foreign member company to a U.S. government representative. That's a good question, and one that has been addressed in some advisory opinions, and even making introductions or door opening activities can count as political in the eyes of the FARA unit. So you do have to be very thoughtful about that type of door opening activity. And key to it is really going to be, what is the communication going to be about? Because that will then turn to some of the exemptions to see if maybe they work. And so the final activity here before we get into exemptions is just fundraising. So broadly, activities within the United States to solicit, collect, disperse, or dispense funds or other things of value for or in the interest of a foreign principal is a covered activity. So examples, again, fundraising, paying travel costs and expense for U.S. policymakers and media to attend a foreign conference can be covered under this activity. Investment activities could be covered, and litigation funding could be covered. And as I think Meredith mentioned, is a topic of interest for the foreign unit, where foreign actors are actively investing in litigation opportunities within the United States. So if your organization is collecting those funds and facilitating that litigation, that can be covered under this definition. So now we got through the first three parts of the FARA analysis. Now we'll turn to the final part, which is we are an agent of a foreign principal. We are engaged in covered activities. Now the question is, do any exemptions apply? If none apply, then we have to register. But there are a number of exemptions that are relevant for nonprofits. The first two we'll talk about here are collectively known as the commercial exemption, but don't let that fool you. The use of the word commercial, it does apply to nonprofits. The Department of Justice has made that clear in recent years. The first one here, agents that are engaged in private and non-political activities furthering the bona fide trade or commerce of their foreign principal are exempt. This does not apply to agents of foreign governments or political parties. In fact, that's a common theme. If your principal is a foreign government, you probably are going to have to register. And it's also not available, this first exemption, where the activities are political in nature. So if you are doing lobbying or advocacy, this exemption is not going to work for you. The next or second part of the commercial exemption is something that the Department of Justice is now kind of rebranding as the domestic interest exemption. The statute talks about an agent is exempt if they're engaged in activities that are not predominantly serving the interests of foreign interests. So if it's in furtherance of bona fide commercial, industrial, financial operations, the activity is not directed by a foreign government or foreign political party, and the activity doesn't directly promote the public or political interests of a foreign government or political party, it could be exempt, even lobbying under this exemption. So this exemption has historically been understood to be pretty broad, but in recent years, really this year, the Department of Justice seems to be moving to narrow it significantly by applying a domestic interest analysis, which was part of proposed rules in January of 2025. And we've also seen indications of this new analysis in recent advisory opinions and other enforcement correspondence. And under that test, the department is looking not just for foreign government influence, but whether the activity, the lobbying activity, is furthering a domestic U.S. interest. So that's a development that we are closely watching. Other exemptions, the Lobbying Disclosure Act exemption, the LDA, is the federal statute governing lobbying for those who lobby the House and the Senate. FARA allows those, if you're required to register under FARA, you can register under the LDA instead. And this is a widely used exemption because, as we discussed, FARA is very burdensome in terms of its reporting requirements, whereas the LDA is pretty easy. And the enforcement of the LDA is a lot less strict than that of FARA. Notable restriction is those who are agents of foreign governments can't use the LDA exemption, and it also does not apply even if you're working for a private foreign principal, if the principal beneficiary of the representation is a foreign government. And then the last two exemptions here, before we get into trends, enforcement trends, the academic exemption. So this applies for agents who are engaged only, and only is a very important restriction here, in activities that further the fine arts or bona fide religious, scholastic, academic, or scientific pursuits. So the Department of Justice views this exemption very narrowly. It does not mean because you're a nonprofit exclusively organized for charitable, academic, or other reasons that it's a get out of FARA free card. No. If you engage in lobbying or other political activities or other types of activities outside of purely academic or religious or scholastic activities, this exemption is not going to work. And then finally, an exemption, the litigation exemption or legal exemption. This exempts agents who are lawyers representing a foreign principal in work connected to a court or agency proceeding where the attorney discloses the foreign principal's entity. Again, this is construed narrowly, only works for lawyers, and it only applies to activities in court or in the agency proceeding. It would not allow a lawyer to go do publicity or to engage in lobbying activities. That would pull it out of this exemption, and registration would therefore be required, assuming we meet all the other requirements. see a question about humanitarian response for fundraising. We didn't include it here, but there is an exemption for humanitarian fundraising. Again, that's a very narrow exemption under FARA. So if you're only doing that, that does qualify as an exemption to registration.
Before we go any further, I do want to jump in with the CLE code. For those of you who are here for CLE credit, that code is Focus 2025. And we'll say that one more time, Focus 2025. So thank you so much, Justin, for covering the nuts and bolts of FARA. Again, just to recap, you need to have all of those elements, a foreign principal, an agency relationship with that foreign principal, and then be conducting covered activities on behalf of that foreign principal. If you don't have that through line, registration and reporting isn't required. If you do have that through line, then you are going to have to register and report unless you have an exemption. The other thing that I'll touch on before we get into enforcement trends, which we had a question on, is penalties. And it's worth noting that there is both civil and criminal enforcement for FARA. The civil enforcement is really geared towards compliance. The goal of civil enforcement is to gain compliance. So the first step in that process will be the Department of Justice reaching out to an organization which has reason to believe should be registered and trying to confirm that registration is required, and then and encourage registration by that person. If if the organization doesn't come into compliance, then the agency has criminal enforcement abilities where it can sue to compel compliance. It isn't necessarily required to go through the civil enforcement process to do the criminal enforcement, but it is typically the way we see things go, that the Department of Justice will first try to work with an organization to fully understand the nature of their activities and then bring that person into compliance. There are fines associated with that can be levied, and there are criminal penalties also on the table. But hopefully we don't find ourselves there. In fact, criminal enforcement is still fairly rare. So moving on to trends. One important thing here is that the landscape is really shifting. During the Biden administration, and the Department of Justice began a rulemaking, and shortly before the end of the Biden administration, they finally, after a long time promising proposed language, they finally issued proposed rules and solicited comments on those rules. And there were a lot of shifts there that, while there was a lot of optimism that the rulemaking would help clarify a very vague and antiquated statute, the community, the FARA bar really felt like these regulations did a lot to muddy the water more so than clarify it. But all of that was thrown into question when shortly after the Trump administration took over, Attorney General Pam Bondi directed DOJ to limit criminal prosecution of FARA to cases resembling traditional espionage. And this really represented a shift in enforcement priorities, where for the past decade, we have seen a significant uptick in criminal enforcement relative to the decades prior. The DOJ has now said publicly that that is not where they're going to focus, except where activities really do resemble traditional espionage activities. That said, the announcement made no comment on downscaling the civil enforcement, and we do continue to see the Department of Justice work on civil enforcement, including audits and sending letters of inquiry, requests to update filings, and pursuing injunctive relief. So we do see civil enforcement continuing, even as DOJ has said they'll dial down criminal enforcement. But where we want to spend sort of the rest of our presentation is talking about this next trend, which is expanding state level oversight in this space. As we see the political climate really ratchet up attention towards foreign influence, we are seeing actors on both sides of the aisle really weaponize FARA and FARA-like laws to target their political opponents. And so we've seen members of Congress from both sides of the aisle using FARA to call into question their political opponents' compliance with the law. And now we're also seeing states pass various trends, pass their own laws seeking to get in on the regulation of foreign influence. And these laws have been called colloquially baby FARA laws. And so far this year, 5 states have passed baby FARA laws. These laws typically mirror the federal FARA in terms of their elements. And the goal is to attempt to regulate disclosure of foreign influence behind state level activities. It is, if you're familiar with lobbying registration and lobbying disclosure, it would be analogous to state level disclosure of foreign relationships, much like there is state level lobbying disclosure involved in state lobbying activities. The laws themselves vary a bit, both among the state laws, and then they vary significantly from FARA itself. They vary in terms of the foreign principles that are covered, the activities that trigger registration and reporting, and most notably the exemptions. The state laws often have many fewer exemptions than the federal FARA does. And they also vary in terms of what is disclosed. We do expect more states to start enacting these laws. We saw one state, Georgia, pass a law in 2024. Ultimately, the governor didn't sign that bill, so it was not enacted into law. But this year, we saw 5 states enact these baby FARA bills into law, and they are going into effect over the course of this year. We have questions about the state FARA laws, including their constitutionality, whether they infringe on First Amendment rights or whether they're preempted by federal FARA. There is some argument that FARA applies to attempts to influence state lawmakers or state officials, and so it therefore preempts states' action on the same activities. We also have questions about how states are going to enforce these laws. The first of them took effect July 1st, and so we still have yet to see exactly how the states are going to implement these laws. So moving on to a few specifics, the law that has probably caught the most attention is a law passed by the Florida legislature and signed by the governor, known as SB 700. This law has a few pieces to it, but most notably, it prohibits entities that intend to solicit contributions in or from Florida from soliciting or accepting money or anything of value from a foreign source of concern. So this is using the state's charitable solicitation registration laws as a hook to limit acceptance of support from foreign sources. Now, notably, it's not all foreign sources of support. It's select foreign sources of concern, and you'll see the list of countries there. China, Russia, Iran, North Korea, Cuba, the Maduro government in Venezuela, and Syria. So there is, importantly, a safe harbor for the first violation if an organization can show that a donor falsely certified that they're not a prohibited source and the organization refunds their donation. But that is only for the first violation. And of course, to be able to show that a donor has falsely certified that they're not a prohibited source, the organization is going to need to include some sort of certification at the point of donation. And so we'll talk about tips for compliance in a second. The Florida law also creates an honest services registry, which will be a database of organizations that attest to their compliance with this ban and other laws, including Florida campaign finance laws. It in order to appear on the Honest Services Registry, you also have to attest that foreign principal is not directly or indirectly producing or influencing content. And so if you have individuals who qualify as foreign sources of concern who are serving on your board or serving in creative positions, you may have to contend with that attestation and what it means for your organization. The law it also comes with various other attestations about compliance with campaign finance laws, and it does authorize the Florida Department of Agriculture and Consumer Services, which currently enforces the charitable solicitation law, to make referrals to the Florida Elections Commission when it believes an organization may not be in compliance. So this law has really kicked off a lot of concern among organizations that solicit contributions in or from Florida. And so we have been working with a lot of organizations on compliance tips. Among these, if you are soliciting in or from Florida, do consider updating your solicitation materials and donation platforms to include affirmations that a donor is not a foreign source of concern. We can work with you on the specific language of that. You may have already seen it included in some of the small fine print on peer organizations, donation pages and solicitation materials, but that is going to give you the ability to claim that safe harbor the first time the state alleges a violation. Another thing you can do is to work with your online donation vendors to exclude contributions from sources that list an address in a foreign country of concern. Although there's not an explicit safe harbor for excluding donations where the address is from a foreign country of concern, we think that this is a very reasonable and practical way to screen contributions and take a good faith approach to screening contributions that might be from foreign sources of concern. You should consider bifurcating solicitations targeting Florida residents if you do have sources of funding from foreign sources of concern. And so this may look like soliciting contributions targeting Florida residents in a different way from the way you solicit contributions elsewhere. Again, we do have questions about the constitutionality of the Florida law and how it will be enforced. The state is supposed to issue regulations to clarify some of the enforcement questions. And we've been in conversation with different clients and other members of other peers about how they are answering these questions. And so we can help to advise on how to navigate these requirements. But it is going to affect a lot of nonprofits because it is so closely tied to the charitable solicitation law, which so many of you we know are complying with that already. In addition to Florida, there have been 4 other states that have enacted FARA-like laws this year: Arkansas, Louisiana, Nebraska, and Texas. And these laws do track FARA more closely, in that they are typically targeting those who are acting as agents on behalf of a foreign principal in certain political activities. All 4 of these laws do narrow the class of foreign principals with which that could trigger registration. And again, it is quote unquote foreign adversarial countries like China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria. The exact list of countries varies from state to state, but it is typically some mix of these countries. The covered activities vary, whereas Nebraska's law is the activities are almost identical to those covered under FARA. Arkansas, Louisiana, and Texas are more closely limited to those organizations who are engaging in lobbying or electoral campaigns on behalf of a foreign principal. And so they are slightly narrower than FARA, but because there are so many organizations that have nationwide lobbying efforts, there still could be a lot of nonprofits that are swept up in this if you have partnerships with organizations, entities, and individuals in any of these countries. The registration and disclosure requirements do vary, but for example, in Arkansas, they require very onerous disclosures about almost campaign finance-like disclosures of receipts and expenditures on behalf of the foreign principal. And so it is going to be a fairly invasive law to comply with. As I mentioned, Georgia passed a law last year. It did not go into effect. And so in large part because it got a lot of pushback from organizations that would be affected. And so for those of you who are concerned about an increase in these laws in other states, do consider keeping an eye on them, especially as new state legislative sessions start in the next year, to watch these bills and, include lobbying on them as part of your legislative efforts if it's going to affect your organization adversely. There are also, just as part of this trend in laws targeting foreign influence, we do just want to flag that several states have recently passed laws prohibiting contributions to ballot measure initiatives from companies that have foreign control. And these laws, for example, were passed in Maine and Minnesota. The courts have started striking down these laws as unconstitutional. So we don't expect many more of these to pop up, but we do think that they can, but we do just want to draw your attention to them as another sign of this general wave of legislation we're seeing across the country. So before we wrap up, we do just have a few compliance tips for nonprofits. And we'll start here. The one big one is to know your donor. As we've said many times now, foreign funding it's not alone sufficient to create an agency relationship, and it's not necessary to create an agency relationship. But if you do have foreign funding, you should be aware and consider how FARA applies to you. And as Justin referenced before, you do want to make sure that if you're make sure you understand your donors and who they are and where their sources of funding are coming from. Another one will be to scrutinize contract and grant language. We mentioned earlier that nuance, that a lot of times whether registration is required will depend on the nuances of your relationship with the foreign partner. And so you really do want to be careful in your contract or grant agreement language to specify to make sure that it's very clear that your organization, a domestic organization, has control over its activities, that the activities are in your own, consistent with your own mission and interests, and to limit the ways in which you are beholden to the foreign partner. Obviously, that's going to be at odds with accountability considerations, especially when a donor wants to make sure you're accountable for the funds you're receiving. But you do want to strike that balance because it can have implications for FARA registration. As we mentioned, make sure activities are very aligned with your mission. If you are engaging in a new line of programming for the first time on behalf of a foreign principal, that's going to set off more alarm bells than if you are engaging with a foreign principal on an activity that you have a long tradition of doing. Do maintain your independence and avoid both in fact and in appearance, and do avoid foreign donations earmarked for covered activities. Whenever you do have a donation that is earmarked for a specific covered activity, do have a conversation with us. We are happy to answer questions about whether you have FARA risks, and we would be very pleased to work through some of the considerations we've talked about here today. Before we leave you all, I do want to just note that the CLE code again is Focus 2025. That's Focus 2025. And we are available for questions for a little bit longer, but we do hope that you have learned something today, and that if you do have questions to us, questions about FARA or the baby FARA state laws, you'll reach out to Venable. We would be very happy to help you sort through these very thorny and politically sensitive issues.